Thank you, Tracy. I'm just really excited to be here to speak with you all about money bail. And first want to clarify what I mean by money bail. I'm not going to assume that everyone in the room knows what I'm talking about. When someone is arrested, they typically go through a process, and in order to release people as they wait for their court date, we have a number of mechanisms in place to ensure that they return to court for their hearing, and also so that they don't pose harm to the community as they wait for their court date. Typically, what we think about is that people have to post a sum of money in order to get out of jail. What I'm going to be talking about is that we don't have to depend on money, and that traditionally we have not relied so heavily on requiring someone to put up a sum of money in order to get out of jail as they wait for their court date. The main thing that I want to raise in using money bail, or one main thing, is that it doesn't guarantee safety. Many people that advocate for the use of money bail will say that if someone has posted a sum of money and then they flee or they do not attend their court date, then the court will have the money they need to go after them. And if you think of it that way, it makes sense. But should the person actually be a high-risk person that actually could possibly pose a harm to the community, if they are able to pay their bail amount and return to the community and then harm someone, I don't think that any amount of money that the court has could remedy that. So we're advocating for less reliance on money and implementing measures that look at risk and more objectively assure safety in our community. The use of money bail also contributes to the judicial system being unjust. And what we're seeing is that there are a high rate of cases being settled through plea bargains. And in 2006, only 3% of cases went to trial. So that there were about 96% of cases that were settled through plea bargains. And what we're seeing is that many people hear the amount of bail that's set for them, and they will say, there's no way I can pay that bail. What's the easiest way for me to get out of jail so I can get back home? And they'll take a plea bargain. So we're seeing potentially a lot of innocent people pleading guilty. And there are studies that are suggesting that people who are trying to avoid a really adverse consequence will admit guilt when they are not guilty.
You also have a situation where in 2012, the state's attorney's office has published the figure that they've dismissed 20% of all felonies. In Baltimore City, for a felony to actually go to trial, it can take close to a year frequently. So you can wait out an entire year in jail or under the financial strain of high bail, and 20% of those folks will have their case dismissed entirely. Kind of an oops by the prosecutor at that point. We shouldn't have charged you. We can't prove this case. In Maryland, 10% is required as a payment, but bail bondsmen will take 1%. And so I find myself on the phone with grandmothers and mothers, begging them to try to scrape together that 1% of bail, and then they owe the other 9%. And part of me feels guilty, because I know what a financial strain that is for the family to have to continue the payments to the bail bondsman. And yet, I also know that my client is physically at risk staying in jail. So we do it as public defenders. But there's got to be a better way. And it's been my experience in talking to clients that actually posting that bail money makes it less likely in some circumstances that they show up for court. What they tell me when I represent them and they fail to appear is that so-and-so posted the bail money in the family. And then there wasn't a way for me to get to court because I was going to have to take 5 buses. And by the time I got there, I was late. And what you have to understand is in Baltimore, some judges issue bench warrants 20 minutes after the start of the docket. So it's really, really crucial that our clients be there exactly on time, if not ahead of the trial date. And so if you're taking that money and causing those payment plans to be enforced with our family members, what you're having is you're destabilizing the whole family. Because the reality is that it doesn't come automatically that my clients get bailed out, even when the family members can get the money together. It might take 4, 5, 10 days. And by that time, my client's probably lost his job if he had it, or somebody else has missed significant work time so that they can't take that day off to drive the client to court. I think that we need to rethink the system, and I think that we need to also recognize that it would be more effective for us to get involved early with these folks that are charged with crimes, many of them who will never be convicted, but nonetheless face some significant mental health and health issues, drug addiction, and that we should instead be concentrating resources on trying to stabilize their life, rather than extracting money from them that's going to cause further destabilization.
I found a number of things that were surprising and a number of things that were shocking to me, quite frankly. First, I found that the U.S. and the Philippines are the only two countries in the world that use the for-profit bail bonding model. And in a lot of countries, the idea of paying someone to post a bond for you would be considered an obstruction of justice. But it's sort of status quo here in a lot of places in the U.S. I also found that for-profit bail bonding is an insurance business, and it's really an anomaly within a system that is necessarily government-initiated and government-controlled. And by ceding control over that part of the process in the pretrial stage, it really causes a lot of harm throughout the whole system. Now, I also found that, in contrast to media stereotypes, bail bondsmen and women are typically upstanding, decent folks who really care about the work that they do and really care about the role that they play in the lives of people who've been arrested. However, the industry in which they work, the for-profit bail bonding industry, is exactly that. It's for-profit. And as such, it doesn't meet the numerous other motives that a holistic criminal justice process requires. For example, public safety, treatment and intervention, and positive social and community outcomes. First, it's a highly profitable business whose primary customers are low-income people who have been arrested. I don't think it's any stretch to consider this a vulnerable community. And bail bonding charges them a steep fee for little to no services rendered. The primary business decision of a for-profit bail bondsman is financial. Can you, or more often your family, pay for the bail bond premium, and can they pay the full bail amount if you fail to show up in court? It doesn't consider dangerousness. It doesn't consider the risk of rearrest during pretrial release. It also fails to recognize the plight of people who can't afford even the bail bond.
There's no good reason in this day and age, knowing what we know about criminal justice, knowing what we know about the people who come through our doors, that we are still using money as a means of release and detention. The outsourcing of a judicial decision to private bail interest is wrong. And there's more than enough proof out there that there are better ways, more efficient ways, more fair ways to make this work. But if you look at the bail system in Washington, we have managed to take away the lie that money is essential and necessary to a bail system. What you need is the truth. If you follow the truth, you'll get